Okay, let's get straight into it. We're taking a look at a really crucial part of deal making today. It's the typical deal process. We're pulling this from Magnus Kjøller's book, Deal Structuring.
Yeah, it's fundamental stuff, really the backbone of how investments and, acquisitions actually happen. And Keeler, well, he brings a lot to the table here. Experience with what, over 70 companies?
That's right, over 70.
Mm-hmm.
As an entrepreneur and an investor, so he's seen it from both sides.
Gives him a very practical viewpoint in this chapter, I think.
Exactly. So what we want to do is kind of break down these fundamental steps for everyone. We'll try to highlight what's really important at each stage, maybe touch on some potential upsides, some challenges, just give you a solid understanding of how these deals generally move forward.
Sounds good. So where does Keeler kick things off? What's step one in this typical journey?
It all starts with the term sheet. Now, you can think of a term sheet as like the initial sketch for a big project, or maybe the groundwork for a building.
That's a good way to put it.
It's basically a non-binding agreement. It just outlines the basic terms, the conditions for a potential investment. It's that first real signal that both sides are, heading in the same direction, hopefully.
Right. And it's important to note, as Keeler points out, it's not always called a term sheet. You might hear other names.
Oh, yeah, definitely. You often hear letter of intent or LOI. That's pretty common, especially in M&A mergers and acquisitions.
Mm-hmm.
Then there's memorandum of understanding, MOU.
Mm.
You might see that more with, say, public sector deals or maybe nonprofits.
And heads of agreement.
Right. Heads of agreement or HOT.
Mm.
That's more common if you're dealing with UK companies or Commonwealth countries.
Mm-hmm.
And sometimes, yeah, a commitment letter does a similar job.
It's interesting, though, why all the different names. Sometimes it's just legal tradition or maybe slight differences in emphasis. Like an LOI for an acquisition might get into more detail early on compared to a broader MOU. But the core idea, like you said, is aligning intentions before you bring in the heavy-duty legal teams.
Absolutely. And here's a key thing. Most of the term sheet isn't legally binding. It's about that initial understanding. But there usually are specific bits that are binding from day one.
Yeah, those binding parts are crucial. They set up a framework for, well, good faith negotiation and protect information.
Like confidentiality, for example, it's almost always binding. Makes sense, right?
Yeah.
You're sharing sensitive business info. You need to protect that. Protects the company's value.
Totally. And another big one is exclusivity, often called a no-shop clause.
Ah, yes, the no shop.
The seller basically agrees, okay, for this period, I won't talk to or solicit other buyers. It gives the investor a clear runway to do their initial work without worrying someone else will swoop in.
Makes sense. And you'll also usually see governing law spelled out. Which jurisdiction's rules apply if there's a dispute about the term sheet itself. And often something about expenses, who covers the costs incurred up to that point.
Mm-hmm. What Giller really stresses is that a clear, straightforward term sheet is just foundational for a good deal. It gets everyone on the same page about the big picture stuff, prevents a lot of potential arguments or misunderstandings later, really sets a positive tone.
Okay, so term sheet sets the stage. We have this initial roadmap. What's next in Kjøller's process?
Next up is due diligence. Conducting due diligence. Think of it like buying a house, right? You get an inspection, you want to check the plumbing, the wiring, the foundation.
Exactly. It's that really thorough investigation into the company before any money actually changes hands. The whole point is to figure out, okay, is this deal actually viable? What are the hidden risks? So you're looking at financials, legal contracts, operations, customer lists, basically everything.
And a standard part of this is setting up a data room.
Right, the data room. Usually virtual these days.
Yeah, almost always. A secure online space where the company uploads all the relevant documents.
Yeah.
Financials, contracts, IP info, board minutes, everything the investor needs to see.
And it becomes this central hub for sharing all that information.
But it's not just dumping documents, is it? It's more interactive.
No, not at all. The investor side goes through everything meticulously. And naturally, questions come up.
Mm-hmm. Lots of questions.
Those questions go back to the seller, usually through the data room, and the seller provides answers, maybe more documents. It's this back and forth, this iterative process, trying to get full clarity.
And this whole deep dive, it's not just ticking boxes, as you said earlier.
Yeah.
What's the real payoff?
Well, the insights you get are huge. You might uncover issues you had no idea about from the initial talks.
Right. And that information is power, essentially. It allows the investor to maybe adjust the deal structure or renegotiate the price or the terms. Or, honestly, if the problems are big enough, it gives them grounds to walk away before committing capital. Kjøller makes the point that it really strengthens the investor's negotiating hand and leads to a much smarter decision.
Makes complete sense. You need to know what you're really buying. Okay, so we've had the term sheet for the initial plan, then due diligence for the deep investigation. What's the final stage Kjøller outlines?
That brings us to finalizing the agreement. So after all the back and forth negotiation, informed by due diligence, the parties move to create the actual legally binding documents. These formalize everything about the transaction, all the specifics.
And it's usually not just one single contract, right?
Mhm.
There tend to be a few key documents involved.
Exactly. It's often a package of agreements. One of the big ones is usually the shareholders agreement, the SHA.
The SHA.
So there's a contract between the shareholders, existing ones, and the new investor. It lays out their rights, their responsibilities, how the company will be governed, rules about selling shares, decision-making processes, all that crucial stuff.
Yeah, Kjøller actually tells this story. I think it was about someone named Johnny, who didn't pay enough attention to preemption rights in the SHA
I remember that example.
and ended up getting seriously diluted when the company issued more shares later. It's a cautionary tale. Really shows why those clauses matter for protecting your stake.
It really does. Details like that in the SHA are critical. Another key document you'll almost always see is the subscription agreement.
Subscription agreement, right?
This is where the investor formally says, yes, I commit to buying these shares, and it details the terms of that specific purchase. Number of shares, the price per share, when the payment is due, etc.
Okay, so SHA governs the relationship between shareholders. Subscription handles the actual share purchase. What else?
Then you have the Articles of Association, sometimes called the bylaws or constitution of the company.
Ah, the articles. These aren't new for the deal, usually.
Typically not created just for the deal, no. They're the company's existing internal rulebook. But they're super important for an investor. Kjøller emphasizes looking closely at these because they dictate how the company operates fundamentally. Things like the company's official purpose, its share capital structure, policies on dividends, voting rights attached to different share classes, how the articles themselves can be changed, even how the company would be wound up. All that impacts the investment's performance.
So how do the articles relate to the SHA, the shareholders agreement? They sound like they cover similar ground sometimes.
That's a really important distinction. Think of the articles as the company's public constitution, filed with the authorities. They set the basic corporate governance rules. The SHA is a private contract just between the shareholders. Generally, the articles take precedence if there's a direct conflict on a core corporate matter. But the SHA can add more specific details or cover things the articles don't, especially regarding shareholder interactions, as long as it doesn't contradict the articles or the law.
Got it. Articles are the base rules. SHA adds specific agreements on top for the shareholders.
Precisely.
Okay, so let's recap Kjøller's typical deal process chapter then. We started with the term sheet, that initial, mostly non-binding understanding.
Setting the direction.
Then the deep dive, due diligence, the thorough investigation.
Checking under the hood, finding the risks.
And finally, finalizing the agreement. Making it all legally binding with documents like the shareholders agreement
The subscription agreement.
and paying close attention to the company's existing articles of association.
Yeah, that's a really solid overview of the core stages. And honestly, just understanding these three basic steps, term sheet, due diligence, final agreement, is so valuable. Whether you're an entrepreneur racing funds, an investor looking at deals, or even just working within a company involved in these things, it gives you a map.
Absolutely. It demystifies the process quite a bit. And look, if this has piqued your interest and you want to understand deal structuring in more depth, we definitely recommend Magnus Kjøller's book, Deal Structuring. You can find it on Amazon. It's been getting really great reviews, actually, and seems to be gaining a lot of traction. It's very practical.
Yeah, it's a solid resource. And Kjøller also has a website, dealstructuring.com. There are extra tools and resources there related to everything we've been talking about. Might be worth checking out.
Good point. Definitely worth a look. Well, that wraps up our look at this chapter. Thanks for walking through with me.
My pleasure. It's important stuff.
Until next time, keep learning.